All right. Molestation. It's a claim you can't defend. There is no defense. Done. Toast. It'll ruin your reputation, it'll ruin your life, and you'll hate the law system. It's an open checkbook for your attorney because they can charge you whatever they want because you're in dire need. It'll probably ruin your reputation, financially bankrupt you, defending that you're innocent. Defense costs start $30,000 to $100,000. We just had somebody come to us last month from another insurance carrier. They were dropped because they had a claim came in for abuse and molestation. He fought it, spent $60,000 defending himself and won in court. But he's $60,000 poorer. And his business has gone downhill because it was in the newspapers and everything else. Remember, they're always in the waters. They're cruising around. They live off of people like you. Okay, you can't be a little bit pregnant, either covered or not. Most important thing you pick up today, you have the right coverage or you don't. You do the right training or you don't. You're going to pay one way or the other. You pay a little bit less with insurance, it's a percentage of the risk, or you're going to be paying out of your pocket for some of these other things. Real important as an indoor operator that you understand these. Property coverage or inland marine, property coverage covers everything inside the building that you would bring in. If you're leasing the building, everything from tenant improvements, carpeting, phones, inflatables, camera system, everything that you bring in. If you also do rentals off-site, inland marine coverage is different than property. It would cover it when it leaves the premises. Property policy does not cover if it leaves the premises. Only the inland marine would do that. Does not provide coverage for equipment of others or rented equipment. So if you have somebody, say somebody wants to have a purple Rhino bounce house and you don't have one. So you give Alex Reed a call and say, hey, you know what? I need one of them purple ones. And he goes, I got one. And he brings it on over, you set it up. Something happens to it, there's no coverage. It's not yours. If you have a loan on it, they're probably going to require that you have property or inland marine coverage. Don't forget business income coverage, very important. Business income pays if something happens to your building and you can't operate. Fire, wind, tornadoes, hurricanes if you're in Florida. It'll pay for your lost income and your normal cost of operating business while you're closed down trying to get reopened again. For instance, if you have a key employee, your manager, been with you 3 years, manager's your right arm, you need to make sure that that person's getting paid. You can keep that person on payroll and that'll help cover that expense. Your lease will still have to be paid. Your phone bill's probably gonna have to be paid. Any advertising that you have has to be paid. Some of your basic coverages, or basic expenses rather, okay? Do I really need this coverage? What's rule number 1? You guys are all scared, man. Nobody's even talking, Jesus. Commercial auto, do you need this? Well, if you load your car up like that with employees going to work or a trade show, yes. Provides liability, medical, uninsured motorist. Your personal auto policy has a business use exclusion, folks. It's on every personal auto policy in the United States, which means you have no coverage if you use your car in business for delivery purposes. If you use it to go to the store, not a problem. Indoor people most likely don't have a business exposure on a business auto. Some do, especially if you're renting off-site along with your indoor center. I get a lot of people that say, hey, my agent told me that my personal auto will cover while I do deliveries. He knows I have an inflatable business. Get it from him in writing. Print it, send a copy to your mom, your grandmother, and your uncle. Save a copy on your computer and put another one in your insurance file. Because if you ever have a claim, that email from that agent stating that you do have coverage for your rental company or your inflatable company or your indoor center, that's your get out of jail card. Covered that. It's pretty clear. You guys, if you're not doing any type of delivery or pickup, that's fine. Non-owned auto, very important coverage. You can add that onto your general liability or your business auto policy. Non-owned auto means if you have your manager run to the store to get some toilet paper because you ran out of toilet paper and they get in an accident, that you have defense coverage because your company is going to be on the hook if they find out during deposition. If they use their car for business purposes during business hours, you could be included in the lawsuit. It's very cheap coverage. Make sure you have it in there. If you have trailers, make sure you add your trailers on. Several people don't add their trailers on. Do I really need this coverage? Rule number 1. Can't be a little bit pregnant. Workers' comp. Do I need it? Yes, you do. You happen to work in an industry that every piece of equipment you have weighs at least 300 pounds. And they're lifting them, and they're moving them, and they're picking up fans, and they're bending over like this and picking them up instead of bending their knees and picking them up. Are they young? Yes. We're old, we do that, everything breaks and falls apart. Young kids, they can throw stuff around, doesn't matter. But later on, it could be a back injury. It could be a strain. Covers employees, it doesn't cover you. It's mandatory in most states. It does not cover subcontractors. So if you call your employees subcontractors, you might have a little bit of an issue here. We'll discuss that later. I know nobody does that. World's greatest saying, they're not employees. Ha 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 ha. IRS and Department of Labor will eat your lunch. If you tell them what to do, how to do it, and when to show up, they're employees, folks. Remember, your insurance policy covers employees, officers, volunteers. Does not cover subcontractors. So if you want to call the people that work for you subcontractors, you'll have an issue later on the workers' comp too. Employee will be compensated if he or she is injured while working for you, regardless of your negligence as an employer. All right, carpal tunnel, lifting's covered. Getting drunk in the bathroom, passing out is not covered under workers' comp. Are we clear on that? All right. Company parties, amazing. If you have a company party, folks, you got to understand this. This is case law. If you have a company party and you ask your employees to come and you have alcohol, you're responsible. Most company parties always have something going haywire with the alcohol. Corporate parties, the corporate management, for some reason, forget who they are and are always getting in trouble with the employees. That abuse and molestation and the EPLI coverage, yeah. Do I really need this coverage? What's rule number 1? Can't be a little bit pregnant. You're either covered or you're not. EPLI, employer's practices liability. This is what we talked about. Business covers your business against claims by your employees that say that their rights have been violated. How easy is that? In today's world, they don't do the job. You fire them. They say, well, you wanted to hire your friend or your cousin or somebody else. No company is immune. Make sure that you have EPLI, folks. It's going to cover all different types of exposures that you have. Discrimination, failure to employ or promote. You promote somebody else, they say, oh, I've been here longer. Wrongful termination, breach of employment contract, sexual harassment. All of those are covered under an EPLI policy. For an indoor center, about $1,500 a year. Cheap, 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 cheap. Do I really need this coverage? What's rule number 1? Can't be a little bit pregnant. All right, what do you do in case of an incident? You cry. If they get hurt on a unit, you are required to preserve that inflatable, not get rid of it. Collect statements from spectators and employees. So important, folks, because what happens is, as you get older, your memory doesn't work as good. And your employees, you have such a high turnover that the lawsuit will usually be filed within 2 years of the incident. So you want them to write as descriptive, narrative letter on what happened as possible. You want to remember that they have unruly friends. The little kid in the red shirt was just a real pain in the ass. We should have shot him, but we didn't. So get as descriptive as you can on those reports. You just need to make sure that it's real clear what happened and get everybody's documentation. Take pictures. Pictures of everything. If you don't have video cameras, I recommend get video cameras. If you don't, you're losing the battle. Number 1, if you're away from the premises, the video cameras are usually hooked up to the internet, so you can see what's going on in your facility while you're not there. And I guarantee you, from one that owned the facility, there's a lot of crap that goes on that's not supposed to go on when we're not there. And when we drive up, it's like an alarm goes off and everybody gets up and acts like they're busy. They're cleaning everything. You know what I'm talking about. All right, notify your insurance company immediately. If you need, get counsel, retain an attorney. All right, documents. How long am I supposed to hold on to these stupid documents, this paperwork? Accident reports, any type of claim, anything like that, 7 years. Employee applications, any write-ups you do on your employees, you want those 3 years. Waivers, all those waivers you get, those pain in the butt piece of paper, 7 years. Accident, if it's settled, keep all the documents 4 more years. So you go past the statute of limitations. Contract, 7 years. Accident not settled, forever. If you don't know it, you're in the kid business. Kids are usually under the age of 18. You're really not in the adult business. That child, if it gets injured, the parents sue you and they get a settlement, that child can sue you again when that child turns 18. So your insurance company is on the hook for that whole period. You want a drink yet? Who do you call if you get in trouble? Call that guy. He's a nice guy. What type of protection should you have? All of the above. And you can use insurance. Certificate of insurance. Everybody says, I just need a piece of paper. I need that certificate for the landlord. I need a certificate for the leasing company. I need a certificate for this. What does it cover? Not a damn thing. It's a piece of paper to make somebody in corporate USA think that they have something. They don't ever read it. It's a disclaimer on the top of the certificate that says that this doesn't change anything that's in the policy. The policy is what goes. That piece of paper is the most useless pain in our butt in our industry. Indoor centers, you guys have maybe 3 or 4 of them. Not a big deal. Rental companies have 60, 70. This nut has like 250 of them. I know he's on speed dial with our office. Yeah, I'm talking about you. All right. Evidence of insurance. It's evidence of insurance. It's not the insurance policy. Coverages and limits can show liability, umbrella, property, commercial, auto, workers' comp, all in the same. Sometimes they're on different ones. It verifies that a certain insurance policy is in effect for stated amounts and coverages and names those that are insured. How easy is it to falsify a document today with the internet, with Adobe? The state of Florida is the worst one. How many people are in Florida, operate in Florida? State of Florida, worst one. We get more calls from Broward County, from the different city parks, asking us to verify certificates because they're falsifying certificates to show proof of insurance for the different parks. For the indoors, you guys don't have that problem. Make sure that you get the certificates. If you're having a subcontractor, make sure that they're the insurance agent sending you the certificate. Don't take one from the subcontractor. You always want to get it directly from the insurance agent so there's no hanky-panky. All right, what do you see on a certificate of insurance? The top paragraph. Nobody ever reads. How many have read the top paragraph in here? You have? 2, 3 people? Very good. This certificate is issued as a matter of information only. Confers no rights upon the certificate holder. Does not affirmatively or negatively amend, extend, or alter the coverage. Does not constitute a contract between the issuing insurer, representative, producer, or certificate holder. It's a useless piece of paper. But everybody wants it for their folder. Insurance policy is what matters, folks. What it says in the insurance policy tells you if you have coverage or not. And if you don't know how to read an insurance policy, you get your insurance agent to walk you through it. If anybody has insurance through us, your quote letter tells you everything that's covered and everything that's excluded. Our quote letters are so intense, people look at them and go, Jesus, do you have to put all that on there? We want you to know what you have, what you don't have. We tell you what you need, and then if you say, well, I don't want that, that's fine. Sign off right here saying you don't want it. Because later on, when you have a claim, you come back to us, we don't want you to say, well, we didn't know. I said, no, well, you did know. You signed right here saying you didn't want it, and that's okay. Just understand we're still friends. All right, so what you're going to see on a certificate, you're going to have the producer up in the top left corner. The name of your company is going to be here. And then over here, you should have contact information, should show up. Very important, the name of the insurance companies that are pertaining to that certificate. You want to make sure, if you have a general liability policy, that right here, that occurrence box is checked. You have two different types of insurance policies with a general liability policy. You have a claims made and you have an occurrence. Occurrence means anytime that claim happened during that policy period, if you get sued a year, 2 years, 5 years down the road, you have defense coverage. Claims made means there's only coverage if it happens during the policy period and the claim is reported. You want to make sure that the policy dates are correct, that you have the right coverage and the right limits in here. You notice here they have the hired auto and non-owned auto. This customer added that on. Very important. The description of operations should be complete. You should have everything in here that explains what the coverages are. It's going to say certificate holder is additional insured. If you're just a certificate holder, you're not additional insured, you have no coverage. If somebody's subcontracting for you. What that means, additional insured status means that insurance policy is going to defend the insured, whoever's on the name of the policy, and whatever work they do for you that they do wrong. For instance, I'm a general contractor. I'm building a house. I don't swing a hammer. I hire a framer. I hire a plumber. I hire a roofer. They come in and do the work. They name me as additional insured on their policy because if she does the roof wrong, it's her fault, not mine. But she did the work for me, it's under my name. Her policy would defend me in the lawsuit because the roof was leaking. That's what the additional insured status does. All right, you always want to be named additional insured with the subcontractors. Certificate holder only does you no good. That just means you have a piece of paper to put in your folder. If you're not named additional insured, it doesn't do any good. Always ask for the additional insured endorsement. And always ask to have that certificate sent from your agent, from his agent. Tips, have trained employees. Follow safety guides every time, not just when it's convenient. Are you going to be called names by your employees? You're too strict, all that stuff? That's fine. It's your name, folks. It's your reputation. And if you don't protect it, nobody else will. Have correct wording in your rental agreement or contract if they're coming in and renting a room. Do not copy somebody else's waiver and contract from the internet. Biggest mistake you can do, you just copied somebody else's mistake. Take several of them, already printed out, go into your attorney, sit down, because they're state specific, folks, state specific, different wording allowed in each state, and make sure your attorney reviews them and gives you the best one for your location in your state. Best $300 you spend. Protect stakes and generators with cones. If you have any type of blower, you have any cords, make sure that they're covered so trip and falls not happening. Do you have anything in writing for what the customer is supposed to do when they come in there? Do you have adequate signage? You tell them where to go, what to do? You tell them what not to do? Kind of important. If you don't have the signage to tell them what's going on, very easy to prove that you were negligent. And you can have a sign company do it. There might even be somebody in the industry that's doing it. Don't let children sit or lie down. Remove them once they get tired. If it deflates, what are you supposed to do? How are you supposed to get it out? All these should be in a training manual that your employees have. The manufacturers have them on there, on the side now. Professional liability, we ran over that a little bit. If you're doing any type of planning where you're putting stuff together, you're hiring subcontractors, you're bringing in cake, you're bringing in anything, this coverage is going to defend you. If you have parties in your location where you're just housing, offering a room, they rent a room, you don't do anything but they come in, you didn't know party planning. Did you choose the pizza company?
Yes.
They get sick, what happens? Can't be a little bit pregnant, right? You either have the right coverage or you don't. Good questions though. If you do any of the planning yourself, folks, you should have the coverage. If all you do is provide a facility, come on in, bounce around, there's the room, bring your own cake. You don't do any planning. You don't have the exposure. But if you do any planning whatsoever, and you try to act like an event planner in any way, shape, or form, whether it's just the pizza, or you hire a clown, or you offer some other things on your website, you cross the line. You can't be a little bit pregnant. Either you are or you aren't. You can't straddle it, folks.
What about you?
Do they name you as additional insured?
No, like they would have.
You have no coverage.
Okay.
They have coverage. Great point. Her agent told her that she had coverage.
No.
Perfect. Great example. Zumba instructor. Everybody's trying to get more revenue in to the facility. If you have a Zumba instructor come in and they have proof of insurance, that's fine. That means that they have insurance. If they name you as additional insured, you both have insurance. So if she does something wrong, somebody gets hurt during the class, her policy is going to defend you. If she doesn't name you as additional insured, remember, subcontractor, got to name you as additional insured, you have no coverage. You have a piece of paper. But she would be covered for her acts.
Okay.
The insurance policy only covers your acts or your employee's acts, not a subcontractor. So make sure that she names you as additional insured. Good question. Failure to provide services is the biggest thing that they get sued for. That's errors and omissions of professional liability. Do I really need this coverage? Rule number 1. I'm too fast with this thing. Any questions?